Number 18 on this afternoon's calendar is the people of the state of New York versus Joseph Sposito. Thank you. Good afternoon, counsel.
Good afternoon, Your Honors. May it please the Court, my name is Donna Aldea, and I represent Mr. Sposito. Your Honors, counsel's error in this
Counsel,
case...
do you care to reserve any rebuttal
I do.
time?
Thank you, Your Honor. 2 minutes, please. Your Honors, counsel's error in this case handed the people, literally, the only direct proof at their trial of the only contested element
Didn't they have the
this offense.
victim's testimony in forensics?
That wasn't direct proof, Your Honor, and the reason for that was the only contested element here was physical helplessness. And the problem with that was that the victim testified that she had no memory. So she wasn't able to say, I didn't consent. She wasn't able to say, I didn't speak.
What about her BAC?
Excuse me, Your Honor?
What about her BAC?
Her BAC, actually, the expert testified here, and this is actually an error in respondent's brief, so I might as well address that. The expert testified here, not that she was definitely unconscious. In fact, what the expert testified to is that her BAC, when extrapolated at 0.26 at the time, around the time when they were having sex, would have been on the Gary-O scale at a level that could have constituted, based on an individual's particular ways of processing alcohol, among other things, unconsciousness or excitement or confusion. And so there was never any testimony from the expert that she was definitely unconscious.
I thought he used the word stupor.
Stupor is the level of the Gary-O scale, so that's what it's called. But then he actually explains, or she, I'm not sure if Barbieri was...
I've done a lot of DWIs, and 2.236 is pretty high DWI.
Yes, Your Honor, it is. However, look, on that point, I mean, I'm not arguing legal sufficiency, right? But on that point, when we look at the evidence that we had in this record, what we had was we had a complainant who couldn't testify as to whether she was speaking or conscious or not. We had her friends that testified that at a time when she was in the bar, right after she threw up, when the expert said from then on, BAC goes down, not goes up. So once she emptied her stomach, her friends were saying she was still talking, she was having a conversation in the bar, she was walking of her own accord.
One of the most challenging thing for you, I would think, in the defendant's statement to the police officers, I think there was a question if she didn't respond when he had knocked on the door. Isn't that the toughest thing you got to deal with here?
Well, that is the claim here.
What's the exact statement, the exact response?
The exact response, so he basically, the part of the interview the whole interview should not have come in entirely.
That's a separate question. Let's just stay with this for a second.
So the part of the interview that shouldn't have come in at the very end, so literally in the last couple of minutes of the interview itself, prior to the invocation of the right to counsel, he is confronted by the police, told that the story he gave before must be bullshit, that no one's going to believe him, that if this goes into evidence at trial, everyone's going to know he lied for 3 hours. And so then they said, so, you know, what really happened? And he said, there was no answer at the door when I knocked, which was contrary to his testimony before that she said come in. There was no answer. She didn't respond when I asked her if I can come into bed, which was contrary to his testimony before that she had invited him in. And she never spoke. She just mumbled or murmured or made a sound when I asked her if I could have sex with her, which was directly contrary to the 3 hours that the jury had heard before. So that was devastating. The direct proof of physical helplessness here came only from that videotape statement.
So if they hadn't had the video statement, your view is it wouldn't have gotten to a jury?
No, Your Honor, I'm not saying that, and I'm not arguing legal sufficiency. There were definitely inferences that were consistent with physical helplessness, but were also consistent with the fact that she was conscious, drunk, and didn't remember. And so the problem here is that what you would have wound up with without the video is exactly what the trial judge said he said. He said, I heard all the evidence, and when I heard all the evidence, I said, I wasn't sure what happened here. I didn't know what had happened, was the trial judge's quote. But then I saw the video. And even after I saw the first part of the video, I still was unsure. But then I saw the last 5 minutes, and the trial judge said, and then there was no doubt in my mind what happened. There was reasonable doubt without the video.
I understand that point. So as I understand what happened below is you got a hearing on the 440.
Correct.
So what you're asking us to do is to find as a matter of law that there was no reasonable view that this attorney could have made a strategic decision that getting in the corroborating statements from the first part of that statement, which were the only evidence that would have supported his testimony, was outweighed the statements at the end of the tape, that there's no conceivable strategic reason that would pass muster.
Well, I mean, there are two parts to that. First of all, in terms of no conceivable strategic reason, it's not a strategic reason, right? It's a reasonable strategy. It has to be a reasonable strategy. There is not a reasonable strategy in the world that can explain a defense attorney waiving a meritorious suppression motion that he would have won, just waiving it rather than going through it. And then at the conclusion of that, after that waiver, literally consenting, handing the people the only direct
to get
evidence.
the result that you are urging us to reach, do we actually have to decide a suppression hearing that actually hasn't happened?
No, Your Honor. Well, I mean, I think you can. So People v. Claremont is instructive on that. And in that case, what happened is there was an ineffective assistance of counsel claim premised on counsel's failure to properly argue a suppression hearing or raise the claims in a suppression hearing, resulting in suppression of a gun. And what's interesting is the majority said, look, it doesn't matter if he would have won or lost. It was a close call under DeBoer. So what we should do is we should remand for the hearing. Now, Judge Rivera, in her dissent, actually said, look, I don't think this was a close call. I think this was clear under DeBoer, and because it's so clear on this record, we, the Court of Appeals, can simply say, grant suppression, and then remand for a new trial.
With all due respect to my colleague, it was a dissent, though.
But my point is that with respect to what the court can do, the court's power, if this is really clear as a matter of black-letter law, which is what I'm saying here, there's no way, there's not even I don't even think that people posit an argument as to the merits of the suppression hearing. There's no question he would have won if he brought it.
Different, it seems to me.
I'm sorry, Judge, go ahead.
Than a gun. I mean, it's hard to, you lose a suppression motion on a gun, the gun comes in, you get a shot at the witnesses in cross-examination. There's no reason why you would want the gun in, because if you suppress the gun, if it's a possession case, it's basically the end of the day for the prosecution. Here, arguably, there is a corroborating reason. You may disagree with it, but isn't that exactly what we grant a hearing for? It's not that you have no relief here. It's what's being afforded is an opportunity for counsel to come in, and time after time this court has said if there is an issue as to that, the proper remedy is a hearing. You air those out. I think there's things in the record here that you can produce, not in front of us, but at such a hearing to go to the motivations for failing to ask for that hearing.
But, Your Honor, the court here, first of all, he did ask for the hearing, he then waived it, so there is a difference here. Secondly,
maybe he decided
actually,
on a different
the posture,
strategy. That's what the hearing would determine.
But the posture is very different here. First of all, the record clearly shows that the reason the counsel waived the hearing, and it's actually in his statement in the record, which was completely ignored to by the appellate division and completely contrary to their deemed potential strategy, he said, the case is on for a suppression hearing, for suppression of your statement, which won't be granted.
Where is that in the record?
That's on page, I believe, from memory, A369.
What is that? Where does that appear?
That is an email correspondence that is
So that's
between-
not in the record then,
Yeah,
really?
that's 440.
Well, actually, Your
That's-
Honor, whether it's in the record or not, here's the
Well,
problem.
then, let me stop you. It's kind of a difficult area for us to get into. We recognize that it's been referenced to in the briefs, but I'm not sure whether we should be considering it or not. Let me take a step back a second.
Can I just address that one part?
No, let me just ask my question, then if you want, you can go
Okay.
ahead. My question is this, let's assume that he has a colorable claim. First off, he's gotten the suppression hearing, and he has a colorable, certainly, claims to make at the suppression hearing. He has a chance of winning that suppression hearing. So then the call becomes whether or not you want the confession, or the interview, excuse me, to be suppressed. And if that's the question, then really, we would have to determine that he would have no strategic reason for wanting that interview suppressed. And when I look at it, I say, well, it seems that counsel was arguing that the consistent behavior of the defendant is really shown by this interview, and it's essential to his defense and his defense theory.
He's embracing that statement.
Yeah, here's the problem, though. If suppression is granted, that's all premised on the fact that the defendant testified at trial.
Right.
If which is a product of counsel's error in not moving to suppress
Well,
the statement.
I would view it the opposite way. You can also argue it could go the other way. The other thing is, too, is that, as Judge DiFiore says, he says, we have to embrace this. This is the only chance we have. It's not a winning strategy, obviously, but it is, I can't call it automatically an illegitimate strategy. The second part is that the 440 hearing doesn't solve this problem at all, because it's something we have to address, because the 440 goes to whether or not he viewed the entire tape, a separate issue.
Correct. Well, that's true. On the 440 point, yeah, I recognize my time is up, if I may just answer the one question.
I did want to direct you to the 440 point.
Okay, so on the 440 point, here's the problem. This claim, it's kind of odd posture, because there are really three separate consolidated appeals before this court. 440 is really the opposite of a direct appeal, right? Because it deals with off-the-record claims. But for ineffective assistance of counsel, because we look at meaningful representation in totality, there can be a meshing. The problem is this, though. The 440 hearing, there are, of course, off-the-record claims about counsel's ineffectiveness that are not currently before this court, about his preparation, whether he even reviewed the tape, and there's a lot of evidence that he didn't, other things, whether he consulted with experts, et cetera. However, because the appellate division explicitly ruled that counsel could have watched the whole tape and made a determination based on having reviewed that record and had a legitimate strategy to put that in, the trial court now, if it conducted the 440 hearing, would be bound by that appellate determination. It couldn't find otherwise.
But don't
it's
we
not
do that?
accurate
Don't
to
we
say,
do that all the time? When something comes here on a direct appeal, don't we often say, this is for a 440 because you could have had a legitimate reason for doing it, which is, it seems to me, what the appellate division was saying here, and then go bring a 440, which is, go make that argument, and in that 440 hearing, you're not bound by us saying there could be a reasonable strategy here.
Well,
isn't that exactly what happened, only at the appellate division?
No, Your Honor, because here, again, there can't be a reasonable strategy, because the problem is it's twofold. First, you waive a suppression hearing that you already have in your hand. Secondly, whether he watched the only question at the hearing would be,
That's
did
a
he
different
watch
argument.
the tape?
That's the hearing argument. There is no reasonable strategy.
Right.
Mr. Defense Attorney from the first action, why did you do this? That defense attorney gives a strategy, and the conclusion is there's not a reasonable strategy. All that the appellate division, I think, was doing here was saying there are conceivable strategies here. We don't know if that was the strategy or not. That's what the hearing, I'm guessing, in a 440 would be, as when we send it back.
But that's my point about A369, which I didn't get to fully address. That is specifically counsel's admission as to why he waived the hearing. In other words, suppression won't be granted.
That's in an email.
Yeah, yes, Your Honor, but here's the problem with it. As an officer of the court, a district attorney cannot take a position or cannot argue a fact of law before any court that is contrary to what he knows the truth to be. Okay? Everybody in this case, including the assistant district attorney, knew that the reason the counsel waived the hearing was because he said, suppression won't be granted. I'm going to lose on the merits. And that's objectively unreasonable. The district attorney then goes to the appellate division and tells them, oh, well, here's a possible strategy. He didn't waive it because he thought he would lose. He waived it for a different reason. He waived it because he thought he might win.
I'm sorry, counsel. Wouldn't that get into issues of the timing of that email and the timing of development of strategy, and when did that really aren't, one, the email isn't even in front of us in this direct appeal. Isn't that all part and parcel to this hearing as to what counsel was thinking and doing on a record that's collateral to the direct appeal?
It's not collateral, Your Honor. This is a direct appeal claim. There are ineffective assistance of counsel claims based on counsel's errors in waiving defendants' constitutional rights that this court routinely resolves without a 440 hearing. And
Counsel,
this is
do you
one of
care to
those.
spend a moment addressing the request for the post-conviction DNA testing?
Yes, Your Honor. So if we win, just for clarification, on this point, in other words, if the case is reversed and remanded, then at that point, that actually becomes moot, because once he has a retrial, he'll be able to test the evidence. And my hope is, of course, that that's how it goes, then the court doesn't have to address that. In the event that that's not the case, then with respect to the post-conviction DNA testing, the appellate division erred because what the appellate division concluded is, since both both counts here, both the rape and the second count with the sexual act, were not based on physical compulsion or force, but rather were based on physical helplessness. The nature and extent of the injuries, which is all the DNA could have dissipated or could have removed the taint of, is not relevant. It doesn't matter. And the problem with
How
that,
is it relevant?
it's relevant because in this case, the people's argument, you don't just look to the statutory elements, you look to how the people prove their case. So the people tried to prove physical helplessness by saying the nature of these injuries was such that it couldn't possibly have been the product of consensual sex. Now, that was contrary to their expert's testimony that said it absolutely could have been. However, that's what they did. So that's number one. Number two, which I think is probably easier and far more direct on that point, is actually that the second count, the sexual act count, was premised entirely on the injuries to the victim's anus. So the anal injuries were the only proof of that. And if she had had sex with somebody else in a bathroom, anal sex with somebody else in a bathroom.
On that point, isn't there DNA evidence at trial from that the anal swab showed that was consistent and a mix with DNA from the defendant? Isn't that in the direct testimony at 48?
Actually, the testimony was...
Testimony of Mr. Mukhtar?
Actually, the testimony, I believe, was that the perianal swab, and I'll quote to the record on it.
That's the perianal, but he's asking about the anal.
Yeah, I think that the perianal, which is the one around the anus, had only the complainant's DNA on it, not Sposito's. But again, regardless of whether that's the case or not, the standard is not that this would have absolutely precluded a guilty verdict. The standard is that if the DNA testing had been done, that would have created a reasonable probability of a better verdict. On that count, where the injury is directly relevant, the appellate division's reasoning falls apart.
So your point is that the second count would have gone?
Yes, the second count certainly would have been affected. Now, I
Did he
can't
also
tell you-
request testing on her underwear?
I believe he did request testing. Well,
did?
actually, I'm not sure if he did request testing on her underwear or not as part of that motion. I know that what he really wanted, I think he did, but I know that what he really wanted to test was he wanted to test the 2 blood stains on the jeans, and the reason for that was that that was consistent with a tear or an injury that would have bled, which is what was found in the anal region. And he wanted to test that because there was no way, based on all the testimony here, that the blood could have gotten onto the jeans based on the sexual act. And the reason for that was she was undressed before they had sex, the jeans were found on the floor under the bed, and then afterwards she never put them back on. So if the blood was there before and there was Brady material that the people had that they disclosed
Isn't
showing...
this way speculative?
Well, so that's the Brady material. So the Brady material that the people had, it was disclosed by the prosecution that the police had received reports that the complainant had had sex with somebody in the bar, in the bathroom, prior to her going back to the house where she ultimately had sex with Mr. Sposito. And so based on that information, that was really the nature for wanting to do the test of that.
Thank you, counsel.
Thank you.
Counsel?
May it please the court, Michael Wetmore on behalf of the respondent, the people of the state of New York. At the time of the representation, the people's evidence really kind of put forth one defense that this counsel had available to him, and that was the defense of consent, a very reasonable defense when you have a situation such as this. It was a rape, but it's not a case of mistaken identity. And I think if counsel had raised an alibi defense, we'd kind of all be here scratching our heads. So at the time of the representation, the way the people's proof appeared, counsel had that kind of defense to go after. And although he ultimately was granted a Huntley hearing, he waived it. He waived it for strategic reasons that actually helped set forth that defense. So really it did 2 things. It lent credibility to the defendant's testimony, and it got the defendant's story out in front of the jury more times than his story would have been out in front of them had they not had the video in evidence. So I think it's quite clear, too, that when you take a look at the actual interview, what the defendant testified at trial and what the defendant said during the interview are consistent. And I've actually even compiled a list of things that are almost identical the things that he said in
Also,
the
there
interview.
seems to have been a suggestion that everyone in this case knows that there was no strategic reason here. How do you respond to that?
I think a strategic reason was actually borne out throughout counsel's case in chief, his opening statement, his closing argument. His idea was that what Sposito was saying mere hours after the sexual intercourse was exactly what he was telling the jury 18 months after the sexual intercourse at trial. So it's consistent because
So he actually gets to use impermissible bolstering this way by saying, not only am I saying it to you now at trial, but it's exactly what I told them the minute it happened.
So that's exact, in a very clever way, actually, what counsel did here was he got in bolstering evidence right under the prosecutor's nose. So the jury actually heard about this interview and the defendant's story, and the defense opening. Defense counsel talked about it, and he goes on to say that none of the people that the DA calls were in the room that early that morning on October 3rd. So he's setting it up. The sex was not just consensual. She wanted it. She asked for it. She encouraged it. She moaned for it, is what he said. And then he goes on to say that he made a number of different times. He was free to leave. He sat there and didn't have to write a statement, but he did. He told them everything. So that's just in counsel's opening. Then the jury gets to hear this interview, Sposito's story, in the people's case in chief, when the people play the interview and call one of the investigators to the witness stand. Then the jury gets to hear Sposito's story when Sposito testifies and takes the stand. Then again, in the prosecutor's closing argument, the video gets played another time. Gets to hear Sposito's story again. And then obviously in counsel's summation, defense counsel's summation, he gets that story out in front of him again. So the rationale here, I think the legitimate strategy is quite clear. The more likely the jury hears something.
What would have happened if you had the hearing, the judge says after the hearing, there's a Miranda violation, and not only that, but I think that the statement was involuntary in the traditional sense. He was deprived water, or he was deprived food, he was deprived sleep, and all of those things. If the statement was found to be involuntary in the traditional sense, not just a Miranda violation, does that change the analysis?
No, because I think at that point, counsel would be bootstrapped in his defense. He doesn't get to rely on that video. The jury gets to hear the defendant's story once at that point, and they get to hear from the defendant at trial, which isn't exactly helpful. It's not exactly.
No, but my point, if you look at footnote 3 in the reply brief, right, because then you could have put it in on cross-examination, but would you be able to put the whole thing in if there was a traditional voluntariness? In other words, the second part where he actually makes the admission, would that come in?
Does the court mean with respect to the jackhammering comment, or with respect to, I mean,
The part where he makes the admissions, actually.
right. So he, in terms of admissions, I mean, he admits to the sex. I don't consider that as admissions, though, because I think what counsel was doing here was he was conceding ground on one area and hoping to gain ground on another.
No, but his position, as you said, is that it's consensual.
Yes,
He's not admitting rape.
right. And I don't think there was ever any admission to any kind of rape in
But to
in the
go
interview
to
whatsoever.
go to Judge Feynman's point, which I think is, as I'm understanding it, let's say did a different way. The statement suppressed on not he was deprived of food and water, but on traditional, it wasn't Mirandized. He then takes the stand. Could he be cross-examined? Would the statement be valid for cross-examination purposes anyway, and to what extent?
To the extent that it was inconsistent with his trial testimony.
And was it?
So when he changes his version kind of at the end of the interview, so that's when the detective sergeant comes in and they begin yelling at him and telling him they believe your story's bullshit, you need to change it, then his story starts to change. So if Sposito so let's say it gets suppressed hypothetically from a Miranda context, and Sposito goes to trial, he testifies, he takes a witness stand. If he testifies that it's consensual, the whole video doesn't get to come in. Just that end part where he had changed his story because he was being berated by the officers. So I think, and again, counsel is not under oath here. He doesn't actually, we haven't had the 440 hearing yet, as Your Honor noted. But I think it is quite clear that counsel saw that he was at a crossroads where it was either go forward with the suppression hearing, perhaps succeed, and maybe it it gets thrown out and you just have the defendant's testimony, or waive the suppression hearing, forego any suppression argument, and use it to our advantage.
But isn't the point, I guess, even if you got it thrown out, you'd still, if your only defense is calling the defendant, you'd still get the bad parts in without getting the good parts in?
Absolutely, and I don't think he would want that. He wanted the jury to hear this story as many times as he could. And what's really interesting is Sposito's story was not inconsistent with what the victim testified to at trial. So if you take a look at the victim's cross-examination, counsel actually kind of went into that direction and used a lot of what Sposito was saying in his questions to the victim. So he asks her, he then asked you if you, and this is on page 1415 of the record, he then asked you, if you want me to be in you, then you put my dick inside of you. And the victim responds, no, I don't remember that. No. I mean, that's awful. No. I don't remember that at all, and I don't believe that that happened. Well, that's pretty compelling for the jury, because she's not saying, no, I was there, I was conscious, and I remember what happened, and this was not it. She's saying she does not remember. She doesn't believe it happened, but it plays into his theory that she was regretting consensual sexual intercourse. And I think that's quite compelling, and I think that can actually be borne out on this record. So another thing that I want to point out, if this court is inclined to see that there was an error here, see that if there is no reasonable strategy whatsoever, it has been almost bifurcated by the appellate division, right? So it's been sent back down for a 440 hearing. I mean, rather than have this court reverse here, I'd urge it to let's see what let's see what defense counsel has to say about what his strategy was. Put him under oath, have him be subject to direct examination, cross-examination, and have him give sworn
If we
testimony.
were to decide there's a reasonable strategy, how does that impact the 440?
I'm sorry.
If we were to decide there's a reasonable strategy, or at least the record seems to provide one, how does that impact the 440?
So I think, because the 440 actually encompasses other issues outside of
Yes,
just this. So
correct.
I do think that if counsel actually did not watch the video, then I think that does need to be explored in the 440 hearing. I don't think that would change that whatsoever, because it really essentially was bifurcated.
But I guess the question is there a limitation on the scope of the hearing if we were to say that there could be a reasonable strategy decision behind this?
Yes, absolutely, for waiving the hearing, absolutely.
But doesn't it still have to be shown that that was the strategy? Or is it that there is a possible strategy, even if he had a completely ridiculous strategy? Let's say, in this case, saying these are the facts, but this was a loser. This clearly was going to be suppressed, and his strategy was, I think we're going to lose the suppression motion. Is it still necessary to explore what his actual theory was, or is it the standard that there was a possible reasonable strategy?
Well, so they have to demonstrate the absence of, or the defendant has to demonstrate the absence of a legitimate strategy. And I think I've just given this court two great reasons why they can't get there, and they've never yet been explained away.
And counsel, on the issue of the DNA testing, do you care to address that?
Yes, thank you, Your Honor. So with respect to, the court had some questions about the DNA testing that was done, specifically with respect to the anal area of the victim. And with respect to my adversary, it's just plainly incorrect. So on page 48 of the respondent's appendix, the analyst is saying this, and I quote, "The anal swab, the interpretation that I came up to was that this profile from the anal swabs is consistent with DNA from the victim and mixed with DNA from the defendant." And he actually goes on to explain that. And he's clearly referencing a chart that's being displayed to the jury, but he says the way we go about doing the actual DNA interpretation is just basically looking at the control sample and comparing it to the evidence. For instance, the first page of the anal swabs has a 13, 14, 15. If we look at the victim's profile, we have a 13, 15. We look at the defendant's profile, there is a 14. So there's clear evidence that the defendant's DNA was mixed with this profile that was developed from swabs of the victim's anus. So there is no, regardless if they get this tested and it's someone else's DNA, there's no reasonable probability that it's going to change these facts that were already before the jury.
Thank you, counsel.
Thank you.
Counsel?
Thank you for your time.
Your Honor, it occurs to me that essentially the position here then is that if you have a murder defendant, for instance, who's being interrogated by the police for 3 hours, and for 3 hours says, I didn't do it, and gives a ridiculous story, part of which was read here. In this case, part of that part, which we're saying counsel strategically would have wanted, was the defendant saying that in the middle of sex, he said, well, if you want me to have sex with you, you will take my penis and put it inside your vagina, which itself strains credulity. That part of it was harmful, too. But it's like having a murder defendant who for 3 hours is subjected to unmirandized interrogation, for 3 hours says, I didn't do it, and gives increasingly ridiculous versions of why he didn't do it, who then for 3 hours is forced to change details in his story, which the jury saw here when this came into evidence, of him admitting, well, maybe she didn't put her breasts on my arm, maybe she wasn't flirting with me, and the story morphs and changes as he's subjected to questioning by the police. It's tantamount to saying that, well, there can't really be a harm for a defense attorney saying, I could get this suppressed as a matter of black letter law, but I'm going to waive that, I'm going to give that up, because at the end, any possible helpful benefit of the video, which in this case I submit there was zero, at the end, that murder defendant says, the police say, you were lying to us all along, and he says, I did it. And that's the only proof that the people had here of the only contested element, which was physical helplessness. There was no other direct proof. Every other proof was circumstantial, and the trial judge himself said would not have supported a guilty verdict because he didn't know. There was reasonable doubt. It's incredibly devastating to say that. And to say that there was a potential strategic consideration here, because Your Honor was saying that here, the defendant testified, and it's possible that counsel was saying all along, I'm going to have defendant testify, so I want to corroborate his story. That is incredibly legally flawed, because the decision of whether to testify at a trial is not counsel's to make. The decision of whether to testify at a trial is defendant's alone to make.
Let's say the testimony of the counsel, as we had already agreed he was going to testify.
But, Your Honor, he can't, because that decision cannot reasonably be made prior to trial at a suppression hearing. The defendant's decision about whether he wishes to take the stand.
You have a case that says a defendant cannot reasonably make a decision to testify before a suppression hearing.
Well, Your Honor, it's not reasonable because he hasn't seen how the people's proof came out.
I mean, maybe you can figure it out from the discovery, right? That what is our strategy?
Your Honor, People v. Nixon,
so
which
you
is
have to
I'm
make
sorry.
that decision at the close of the people's case.
The decision is typically made at the close of the people's case, but in any event, again, it's not counsel's to make. And here we know that counsel made the decision to waive the suppression hearing before any of that came out. And on prejudice and strategy.
No, wait, the decision to testify at trial is the defendant's to make.
Correct.
The decision to have the hearing or not go forward with the hearing is not necessarily one that
It's
belongs
not
to the
defendant's
defendant.
to make, but what we're.
Okay,
But,
so, I mean, so the problem I'm having with your position is that it comes pretty much to you're asking us almost to adopt a per se rule that if you waive a hearing that's been granted for whatever strategic reason you may have, that's per se ineffective.
Actually, Your Honor, I'm not. What I'm asking you to do is to apply the meaningful representation standard and to say when the defense attorney furnishes the people with the only direct proof of the only contested element, that is ineffective if he definitely would have won that hearing. And here, he definitely would have won that hearing. And on that point, Your Honor, actually, the per se rule that's being advocated here, and if you step back a little bit, it's really unbelievable, is being advocated by the people. What the people are saying is the only way a defense counsel's decision to waive his client's constitutional rights to a trial at which his unconstitutionally obtained statements are not used against him, the only way that can be unreasonable is if we show that the attorney never knew what the statements were. That's crazy. We don't need to show that.
There's no reasonable strategy not to move to suppress a gun, because if you suppress it, the case goes away.
And here, there's no reasonable strategy not to move to suppress a confession, which is what this was. The last 5 minutes of
We're going
this.
to equate a confession with a gun from now on.
You equate it because if that's the only direct proof of the element of the offense, of the element of the offense, then it's the only proof of his guilt. It's the only proof of his guilt, because nothing else
Then
was
we go back to,
contested.
they wouldn't have gotten to the jury without the confession.
Your Honor, you know what? It's possible. It's possible that the trial judge would have granted it. You know what certainly would have happened?
Does it matter if it's an admission of some facts but not a confession?
Excuse me, Your Honor?
Does it matter if it's an admission, a partial admission of some facts but not a confession?
Well, in this case, Your Honor, it was a confession with respect to the element of physical helplessness, which again was the only thing that was contested. But more than that, with respect to the impact of this on the trial, which really goes to the meaningfulness of this decision, with respect to the strategy here, the other part that really is kind of, I guess, being sidestepped here by the prosecution is that he could have gone through with the suppression hearing, gotten the statement suppressed, and then said, okay, I consent to you using it at trial anyway. That would have been his choice to make at that later stage. He could have let the prosecution use it. Why would you give up the right? A suppression hearing affords so much more, which this court has recognized in other contexts. It affords the defense a preview of the people's case. It affords the defense an opportunity to cross-examine the people's witnesses and to get testimony that they can then use to impeach them. Counsel forfeited all of those things here. What is the strategy for that?
Also be arguing that the consent to use the statement was ineffective?
Excuse me, Your Honor?
Wouldn't you also then argue the consent to use the statement was ineffective?
Well, in this case, Your Honor,
Because essentially that's what they were doing.
in this case, Your Honor, it definitely was, but my point is that the harm and the reasonableness of counsel's decision and the absence, not of any strategy, because it's not enough to say, well, we can conceive of possible things that counsel might have been thinking. The requirement is that the strategy be reasonable and legitimate.
Thank you, counsel.
Thank you.